let's talk about the anatomy of a medical malpractice case. Specifically, let's talk about what happens pre-trial. We all hear about healthcare providers being sued, and frequently the outcomes of those cases make the news. But what really happens in a lawsuit? Well, the first thing you should know is that malpractice cases don't always result in lawsuits. But that said, clearly some event precipitates it. It starts with an adverse outcome and then an allegation or a demand for compensation, which the provider would report to his or her insurance company as a claim against the professional liability policy. There are generally 3 different pretrial outcomes. The first possible outcome is voluntary discontinuance. Sometimes the person making the demand or malpractice claim, and this person is called a plaintiff, sometimes that person and their attorney will voluntarily discontinue the claim. Typically, this is after expert review if the potential for a settlement or a jury verdict in their favor is questionable, or realistically speaking, the expected payout is not sufficient in the eyes of the plaintiff's attorney. If the plaintiff decides to continue, a judge can dismiss a claim. When a judge dismisses a claim, it is generally because an attorney has filed a motion for summary judgment. This is a request for the court to rule that the other party has no case because there are no facts at issue. In other words, they argue and convince the judge that the case shouldn't go before a jury at all. That's the second possible outcome. The third possible outcome would be that the plaintiff and defendant come to an agreement on a settlement. So what can you do to make one of the first 2 options viable? Always report significant events or anything where you feel like there may be some liability exposure. And once reported, your carrier will determine the best course of action and may proactively assign you legal counsel. You'll want to meet with your attorney as soon as possible to develop a strategy to prepare sufficiently for a deposition. You'll need to ask your insurance company for guidance on selecting an attorney. They often have a panel of approved medical malpractice attorneys that they'll want you to select from. In fact, they may assign one to you based on what they know about your case. As the defendant, you will likely be deposed by the plaintiff's attorney, and the purpose of this deposition is to obtain a detailed and documented history of your recollection of events. A deposition, if the case goes to trial, will provide the foundation for which the plaintiff attorneys and yours will question you on the stand. The objectives of the plaintiff in taking your deposition are 1, fact-finding, establishing malpractice, impeachment with deposition at trial, assessing your ability, and jury appeal as a witness. Now, it's important to note that for a case to be considered malpractice, there has to be proximate cause. That means there needs to be a reasonable connection between the act or omission of the defendant and the damage which the plaintiff suffered. Sometimes, even if there was an error on the part of the defendant, it becomes clear that the error didn't actually cause the outcome. Something else did. Another thing you should know about your deposition is that the testimony provided in that deposition can be used during the trial, and that would be the case if during an examination in court your testimony differed from what you stated in the deposition. Finally, the deposition is also a means for them to assess your presence and your presentation to determine how well you will appeal to the jury.